Bismillahirrahmanirrahim. Hello everyone. I hope you all have a wonderful day. Today we are going to discuss about International Court of Justice, and that's the picture of International Court of Justice. We will discuss its following components. We will discuss its history, what are the functions of International Court of Justice, what is the membership criteria, and how its members are formed, what is the jurisdiction authority of International Court of Justice, what are the criticisms on ICJ, and what are the reforms needed for the effective working of International Court of Justice. So without further ado, let's start our discussion. Let us first start with the history of International Court of Justice. In this slide, we will discuss how the International Court of Justice was formed, what were the phases that came in between the formation of International Court of Justice. So the story starts from the Hague Conference that was initiated by the Tsar of Russia, Nicholas II, and it involved all the major powers of the world. And with that Hague Conferences, a permanent court of justice was formed. But Second World War was the main reason it ended, and its last public session was happened on December 1939, and it issued its last orders on February 1940. So after the Second World War, we all know that United Nations was developed, and United Nations charter formed another court with the name of International Court of Justice, and it ended the permanent court of justice, permanent court of international justice. International Court of Justice was formed in 1946, and its statute of International Court of Justice was similar to that of its predecessors. So let's start to discuss about the introduction of International Court of Justice. So ICJ plays an important role in the implementation of international law. It also forms international law. It also adds new laws into the international law book. So it is also known as the World Court. It is one of the 6 principal organs of UN, and it is based in Hague, city of Netherlands. So it is composed of 15 members selected for 9-year terms from the United Nations General Assembly and the United Nations Security Council. That was the little bit of introduction about ICJ. So what are the core functions of ICJ? Its core functions are to settle legal disputes between the states, between its member states, and it provides advisory opinion on legal cases that are submitted to it. And since its creation, it has done around 177 cases in its consideration, and although respected widely, ICJ decisions are only consultative in nature, and that's what is the major problem of ICJ. Its decisions are consultative and advisory to its member states that are in the dispute. So what is the membership of ICJ? It is composed of 15 judges, as I said earlier, and they are selected for the 9-year terms of the office by United Nations General Assembly and the Security Council. 1/3 of the court is elected every 3 years. Judges are eligible for re-election, and that's the criteria for membership. And elections are held in New York, United States of America, annually, or at the occasion of annual autumn session of General Assembly. The president and vice president are elected by the members of the court every 3 years by a secret ballot in the ICJ. So that's the membership criteria of ICJ. What is the jurisdiction of ICJ? According to the Article 93 of UN Charter, all members of the UN can be parties of the court. The court jurisdiction over states is only when the states accept the jurisdiction and are willing to be bound for jurisdiction. There are 2 parts of ICJ jurisdiction. One is contentious jurisdiction and the second is advisory jurisdiction. There's a little bit of difference between them. Court has a power to settle a dispute when parties agree. Only when the parties agree, it settles the dispute. And its advisory jurisdiction, court provides advisory opinion to the UN organs such as UN General Assembly or Security Council. It forwards them the advisory opinion if they require in any case. Non-member states can also become a party to the court if they are willing to be bound by the court's jurisdiction. So that's what is the jurisdiction criteria of ICJ. Let's move on to the criticisms that are being done on the ICJ. I have listed few of the common criticisms that are done on ICJ, and one of it is that its ineffectiveness of ICJ due to its advisory nature of jurisdiction. And there is a reason for that why it is being advisory. I have listed that it is because of the principle of sovereignty. If courts decision are made compulsory, then the state's sovereignty would be hurt and the state won't be able to exercise a power in its internal matters. So that would be a very bad kind of situation. So most of the states don't agree on the situation, and that's why I think the court can't be of compulsory nature. Court's decision, ICJ deals less than 100 cases in a year, and that's another criticism that is being done on ICJ, that it has to handle a lot of cases in an year so that the disputes can be resolved quickly. Judgment can be enforced if less than 9 votes of Security Council members, and even if a single veto comes from a permanent member, the jurisdiction is completely lost. It can't be processed further. So there are a lot of, I would say that there are a lot of limitations in the ICJ's procedures. So let's talk about the reforms that are needed for ICJ to work effectively. I have listed a little bit of debate in it to let you know the difficulties in reforming the stature of ICJ. So some scholars advocate that the 1945 UN Charter may need to be supplemented among constitutional democracy by a new UN constitution based on human rights covenants, democratic peace, and compulsory ICJ jurisdiction. So there are multiple reasons why the compulsory jurisdiction can't be implemented worldwide. Compulsory adjudication by the UN system of international disputes among states is utopian. Utopian in a sense like it can't be done in a world that is full of disputes and the states don't agree with each other most commonly, and the court's jurisdiction was intentionally limited as at its outset because they knew the states won't agree to have a compulsory jurisdiction. This prevented ICJ from being totally ineffectual as a military staff committee of the UN or from becoming a tool of either both superpowers and losing its neutrality. There would have been too many risks. So I have listed a whole debate in that slide, but the main core idea is that if a compulsory jurisdiction would have been the part of ICJ, ICJ wouldn't be there in the future right now. ICJ can take some measures to avoid such risks. For example, it could establish an appellate review procedure. That's the reform that ICJ should implement for its effective working. It has to form an appellate review procedure like the World Trade Organization dispute settlement mechanism. It can be really helpful for settling the dispute in a procedural way. So that were the reforms, and that was all. Thank you very much. Allah Hafiz.